Hi, everybody. My name is Frekhtman. I'm an attorney. I just got off a trial, and I want to show you exactly how I got $1,400,000 in a settlement on a case where the city of New York offered zero, not just at the time of trial, but all the way through when we started the case many years ago, all the way through litigation. The offer was always zero. And we took it to trial and we got $1.4 million. And I want to show you how. So we started off by picking a jury. We were in jury selection. And actually, in this case, it took 3 weeks to pick a jury. The trial finished February 3rd of 2020 in civil court in Brooklyn. And it was a slip and fall case. It was a slip and fall on stairs. A mother was picking up some kids after school, and she was inside the school. She had picked up her kids, and she was going down a side exit to go into a schoolyard, and she was going to go home. And as she was walking down the steps, it was about 12 steps, she slipped and she went on her back. And at first, she thought nothing of it. She thought, I'm okay. It was embarrassing. And she thought, I'm going to go home. It'll go away. And she did that with her child. But the pain didn't go away. It got worse progressively, and she ended up needing a back surgery because of it. And so we filed a lawsuit against the city of New York and the Department of Education, who oversees the schools. And they didn't pay because they said, well, it was raining outside. What do you want from us, right? They said, when it rains, people are going to track in some water. You're going to have puddles on the stairs, and people have to be careful. What do you want from us? So they completely were denying the case, didn't want to pay a penny on it. So we spent some time picking a jury. We really looked into who we thought could be a fair juror on this case. And when I started picking the jury and talking to the panel of prospective jurors, I told them, I want to be honest with you. I want to tell you what my fears are. And I want you to tell me, what should I be worried about? And we even asked them, and we were just completely vulnerable with the jury and let them tell us what we should be worried about as lawyers representing this mother. And some of the things they said were, well, a school has to be, has to clean, has to be careful, but a school can't be cleaning these stairs every minute. So you have to temper your expectations. And the other thing they said was, well, there's not enough proof the school knew about this puddle. Where's your proof that they knew about it? Because if we saw that you could show us the school or the janitor knew about the puddle, but still didn't clean it up, well, then you got them, then you can win. But if you can't prove that, then you don't have much of a case. And then other people said, well, people have to watch where they're going. It's an individual responsibility type thing where if you're walking and you slip on water, you have to be partially at fault. They couldn't, leave room for the possibility that someone could be tripped or someone could be thrown violently due to something that the school did. Some people thought that a person is responsible for their own actions. So they have to look where they're going, they have to hold the handrail, and that became a big issue in the case because when they asked my client, were you holding the handrail? She was honest and she said, I don't remember. And in the closing argument, the defense lawyer, I thought this was the best thing he did the whole trial. The defense lawyer, the lawyer who represented the city, argued, he said, well, it was a red handrail right in the middle of the staircase. It was screaming, hold me, hold me. How can you not hold the handrail? And that was a great point. So, so that we were up against that. And then they said, the plaintiff knew it was raining. She had a wet umbrella. She should have been more careful. And then things like that. So these were things that people were, that we should be worried about. But it's good to get that out there in the open, because once you get that out there in the open, you really get into the heart of the case and you start discussing the issues. And then the other thing we talked about were like following rules, because we had some evidence that this was a recurring condition, meaning this happened over and over again, that whenever it rained, parents would complain that these particular steps would get wet and that the school kind of swept it under the rug. They wouldn't do anything about it. So we had some of that evidence and we used some of that. So then, so we picked a jury, we got assigned to a judge, we opened up, we did an opening statement, we put on some witnesses, we put on the plaintiff, we put on the defendant custodian, and we showed some of the issues with the safety violations that the defendants had. And then we pretty much were, the way it works in Brooklyn is they split the trial into two parts. The first part is liability, meaning who was at fault. And the jury could say the school was at fault, 100%. The jury could also say the plaintiff, the mother, was at fault, 100%. Then obviously we get 0. And the jury could also say they were 50-50, 80-20, any kind of percentage that adds up to 100, right? So that's basically, so while the jury was out deliberating in the jury room, thinking about the issues and trying to make a decision as to that issue of who was at fault, we reached a settlement and the city agreed to pay $1,400,000. So I wanted to go through the closing argument. And the closing argument, this was a picture of the school, and we started out by saying, we kind of took them to an alternative reality. And we said, what if this was a happy ending? What if this was just a mother who went to school at 3 p.m. to pick up her daughter, pick up some other kids like she always did, and she was able to get her daughter, go home. She lived like 2 blocks away, cook dinner, have a good night. What if I was able to tell you that story? I wish I could. And that was kind of like an alternative reality, because in reality, what happened was something completely different. She ended up needing a back surgery with a spinal stimulator. It was a horrible injury. So then we talked about the defenses. And when we talked about the defenses, we brought up the fact that it was kind of like what they were really doing was, and I use this analogy that I think other lawyers have used, that it was kind of like they were inviting us into the mud springs, right, or into a swamp. They were like slinging mud. And I argued that they don't really have true repentance, because true repentance, like if a boy throws a ball and breaks a window, if his father marches him over to the neighbor whose window he broke, that boy has to say, he has to admit it, say, I did it, promise he won't do it again, and then make it right, like, get some money, give it to the person for their window. But here, they didn't really do that. They never really admitted that they did anything wrong, and they kept blaming my client. They kept saying it was her fault, we didn't do anything wrong, our procedures are safe, even though so many parents complained and we had witnesses who saw that it was wet before our client fell. So we went into this, the fact that the defenses were frivolous. And then we brought this up, that what they're really doing, because they brought up so many things, that they're just throwing things up against the wall and seeing what sticks and hoping that one of their arguments is going to stick with you, so you're going to vote for them and dismiss this otherwise meritorious case, which really isn't fair. So then we got into the nitty gritty. We got into all these things, and we said, did they do this? And this was a huge school, 80,000 square feet, probably like you could put 2 football stadiums in there. And we said, did they have maps? And the answer was no. The answer to all of these is no. Did they have maps? Did they have the yellow caution signs? Did they have an umbrella bin? Did they look? Did they mop? Looking, basically just inspecting, some kind of inspection, even if it's once an hour, but they had no system of inspections. They just pretty much said, well, if we saw it, we would take care of it. Well, yeah, if you saw it, but you're dealing with an 80,000 square foot building. What if, and the other thing is, they had one janitor, one guy who was there at the time. They had other janitors who would come after school is closed. They had janitors maybe early in the morning. But at this time, in fact, during the entire school day, they only had one guy. So we were like, how can one guy do this? He's overwhelmed. A schedule, they didn't have a schedule. They didn't have a checklist. They didn't have those peel and stick strips, basically like the non-skid strips that you could just either, there's a spray you could put on a step, or there's a glue that you could attach it to a step and it makes it like sandpaper so you wouldn't fall. They didn't have that. They didn't report back. So for example, if one of the janitors did see something, he wouldn't report back to the custodian, so the custodian could assign someone else to fix it. So they had no system, and they didn't follow the industry standards. And then basically they only had like one guy, the janitors. So that's and then I kind of said, this is kind of like the point we're making is almost like a signal of truth through all the noise, because they're trying to throw the mud and see what sticks. You have so much going on, but you have to look at the signals of truth through all this noise, and that's what I tried to focus on, the heart of the matter. And then the fact was that we got out through cross-examining the custodian. We found out that his office was just 2 feet away. It was just the width of a wall from the stairs. So on the left, you could see the stairs where it happened. This is the stairs where it happened, where she slipped. And you can see this is his office where he has it's a custodian closet. He's got all the supplies there, the mats, the buckets, the mops to sweep up. And it's just the width of a wall away. And he's sitting there all day, but he doesn't know like if he ever looked at it, when he looked at it. There's no system. So we really harped on that. And then the fact that when they asked him, well, do your custodians report back to you if they see a puddle, to have some kind of system, because communication is a two-way street. And I brought up this thing for when I was a kid. I used to see it on TV. The more you know, it was like a public service announcement. The more you know, the better. So why don't you work as a team so everybody can communicate with each other, right? So then, and then we asked him, well, do they report back? And he said, no, they don't report back because they don't monitor me. I'm the boss. I monitor them. So that we really like harped on that testimony because it made him seem like a greedy, all important boss. Like, oh, I'm so important. They don't monitor me. So we said, yeah, communication is just going to lead to more frequent inspections, which is a greater likelihood of finding the problem and getting rid of it. Then we talked about the fact that a caused and created argument, which under the law means that they created the condition, and it was a puddle of water. These steps had little holes in them. I don't know if you could see it on the right, little, like the paint was chipped, and it created these little ridges, and the water would collect in those ridges, and there were chips and cracks, and they painted every year, but they didn't really put any non-slip surface, which is required by some of the industry standards. And so we argued that for 86 years, it just kept getting worse and worse without following the industry standards. And then we had an expert come in, and he talked about the fact that, if you throw something down a sidewalk, it's not going to go very far, but if you throw it on a hockey rink, it's going to go really far, all the way to the other side. The coefficient of friction and what's slippery. And we said that, yeah, on a painted surface that's non-porous, that you can't penetrate during rain, someone's foot is going to be very, very slippery since that water cannot penetrate the stair. And then we talked about the custom and practice, the ASTM and SI and C standards, that a surface likely to have wetness must be slip resistant. And those are the strips that I mentioned earlier, non-skid, as well as the slip resistant coating they could have just sprayed on. These things cost like $5. They could have just bought this, sprayed it on, and then it would have been safer, but they chose not to. And that was all, it has to be like framed as their choice not to. And that was the basis of them violating the safety rules and being held accountable. And I brought up something like a smoke detector. I said, what if a smoke detector only works 1 minute out of every hour? Is that safe? Of course not. What if a baby monitor only works 1 minute out of every hour? No, you need them to be always working. But here, I said, even if they would have inspected just one time, let's say on the hour, every hour, that would have been more safe, because at least they would have caught the puddle, let's say at 2 o'clock, and mopped it up. And then at 3 o'clock, when our client's going down the stairs, it would have been safe, because we had witnesses who saw that same puddle around 2 o'clock, 1:45, 2 o'clock. So we could prove that it was there for an hour. And then this is another checklist. I actually used this during opening. This was the mats, the yellow caution signs. I actually drew it out on a whiteboard myself. And then I went through it, all the things that they could have done and they didn't do. And I said, this is as easy as A, B, C, 1, 2, 3, because we had 6 things. And so I think this was pretty good. A lot of the jurors, they kind of were nodding and they liked this. And then I said, look, the rules are there to solve problems, but then the city of New York chooses not to follow the rules. So what is that like? And it's almost like, yeah, somebody burying their head in the sand. Like, why would you do that? And then we talked about safety being a choice, not a chance. So you can choose to put it in writing. You can choose a schedule, a checklist. You can choose meetings with staff and all these things. Or you can choose not to have a system at all. And that's what makes it dangerous. And then we went through the jury instructions. The jury instructions are what the judge reads to the jury, and then the jury has to answer questions. So one of the questions was the puddle of water a cause of the fall? So meaning, was the puddle, the defective condition or the slippery condition, a substantial factor in bringing about the slip and fall and the injury? And so our experts said that, in his opinion, he was an engineering expert, a PhD, and he said it was a substantial factor in causing. And then we said, look, to be a substantial factor just means it has to be like a major reason. It has to play a real effect in bringing about the ultimate result. So it can't be trivial, slight, like a remote island somewhere. It can't be remote. It has to be one of the reasons. And I gave an example, like boxing. You can be in a boxing match, get punched 20 times. Which of those 20 punches was a substantial factor in the knockout? Well, all of them were, right? Because all of them had an effect in bringing about the fall, as opposed to something that has no effect. And another example with milk, you could say, well, it's a single drop of poison in a gallon of milk, it still has an effect. It can still kill, so it's still dangerous. So it doesn't have to be substantial in the sense that, all of the only thing that caused it was the puddle. It just has to be one of the reasons. And then we went through basically the burden of proof. Which side do you believe? Which side tip the scales? It just has to be like a feather, because it's 50.0001%. It's not reasonable doubt like in criminal law, where if you have a doubt, you have to acquit and the defendant who's accused of a crime goes home. Here, it's not like that. Here, it's just who has more proof, which side do you tend to believe more? So who tips the scales? And then we talked about, then we basically closed up, and I thought it went pretty well. The trial, it was about like 3 weeks to pick a jury. The trial itself was probably another 2 weeks, so altogether 5 weeks. It was kind of a long trial. We had a bunch of witnesses. We had the plaintiff, we had the defendant. Actually, we had a teacher as well who was a witness. We had a non-party witness who was another parent who actually was away, so we used her deposition transcript. We had the expert. So yeah, it took a little bit of time. I mean, next time the way I would do it differently is I would probably try to do it quicker. I would try to do it quicker. We had issues in jury selection where in New York, we don't have a judge during jury selection. It's just lawyers that go into a room. So we had to work everything out on our own. And we had a lot of disagreements, so we ended up having the judge's law secretary supervised. But I thought the jury selection went well. And there's a lot of delays with the court system, just the way everything worked. Like you would show up at 10, but one of the people in your jury pool wouldn't show up until like 11, so everybody else is just waiting till 11. Then you take lunch from 12 to 2. So it was just like, even though you have from, let's say, 9:30 till 4 p.m., even 4:30, you don't really have that much time because the large lunch break, people coming late, this and that. So anyway, but I thought this was a good result. I mean, 1.4 million. A lot of people have asked me about this. They've said, how did you get 1.4 million on a case? That a lot of lawyers won't even take a case like this. They just think that, if it's raining and you fall on the stairs right near the exit door where people are tracking in water in and out, they said that's like an impossible case. That's like a case that should just get dismissed. You should get nothing, or maybe you get a few bucks. But I think we did pretty well. I mean, we were confident. We really we didn't stop. We left like no stone unturned. Another big thing that we did was we got all the Freedom of Information law, the FOIL documents. We got everything. And we looked through all the FOIL documents and we found these manuals, and the manuals were like from 1970 something. And the manual said, if you have, water, if it's a rainy day, if it's inclement weather, you have to have mats. So we said, look, they violate their own manual. So that kind of helped. And then, altogether, I think it was a good result. So let me know what you guys think. Feel free to ask any questions. I'd be happy to answer any questions. Let me know if you have any ideas for future videos. We'd be happy to answer your questions, what you care about. Okay, have a good night. Stay safe and stay healthy.